Dear students, this is a new lecture in the field of the international organizations law. So in the previous lecture, we were talking about the categories of the international organizations. Now, and we have mentioned that there are many criteria that we can rely on in order to classify the types or the categories of the international organizations. So we mentioned that according to the geographical scope of them, we have two kinds of the organizations. We have the universal and the regional organizations. And according to the jurisdiction, we have the international one or the universal one, in the meaning that it has the jurisdiction on rather than one field in the field of international law. And we have the limited jurisdiction ones. So the first one is the wide jurisdiction, and the second one is the limited jurisdiction organization. Also, we said that there is two kinds of the organizations according to the actors addressed by the provisions of the international organization. So we have two kinds. The first one is the organization between states or interstates organizations, and we have the supranational organizations like the ICC, for example, as I told you before. Also, the statute of the European Court of Justice. If you have a look regarding this statute, I mean the European Court of Justice, you will recognize and realize also that this court, as international organization, it is a supranational one, simply because the provisions within this statute or its statute, it is directed to the individuals who are the population of the member states. Okay, so now we will move to another topic, which is the question: how do international organizations emerge? I mean, how the international organizations, how are they established? How do they emerge in the international society? And this is an important question, but to answer such a question, you have to revise the definition of the international organizations. As you may remember, the definition of the international organization as shown here. I told you before that it is bulk of international actors' wills, تجمع إرادات أشخاص من دولي عام, in a shape of a permanent committee. And I told you this is important character. It is impermanent simply because it differentiates between the international organization and the international conferences. And it is founded and established by an international agreement, whereas it is a treaty. It is called the treaty or the establishing treaty of the international organization. المعاهدة المنشئة لمنظمة دولية. It has independent will, provided with a special legal system or the internal system, as I told you, and it has its own major organs, and it has not only the major, we have subdivisions actually, or subsidiary organs. We will discuss them later. All together, they work in order to fulfill the targets and the aims of the international organization. Actually, what I do care here in the definition is this: that is founded by an international agreement. Okay, so the international organization is established through an international treaty. So pursuant to this definition, the organization is established through an international treaty. This treaty contains the rules and provisions which regulate the internal and the external activity of the organization. This treaty will last as long as the international organization exists. Simply, for example, the United Nations. The United Nations as organization, it was established after the entry into force of the United Nations Charter. So the Charter is the establishing treaty of the United Nations. This Charter will last, it will continue existing in the international society as long as the United Nations is existed. So if the United Nations collapses, then in this case, the treaty collapses. Okay? So this is what we mean by this statement, that the treaty lasts as long as the organization lasts or exists. So they are linked to each other because the organization is founded, or it was founded through the international treaty. So if the treaty vanishes, then the international organization will vanish accordingly. Okay, so what we care about here is that how do international organization emerge? The international organization is, or they emerge based on an international treaty. For example, the United Nations, it was founded by the United Nations Charter. The ICC, it is founded according to the Rome Statute. Okay, the European Court, European Convention. Okay, so the convention or the treaty is the reason why the United Nations is existed. Okay, so the question here is the treaty constituting the organization similar to the other treaties. الآن يعني بالعربي هيك احنا بنقول انه الانترناشونال او الانترناشونال اورجانيزيشن بتنشا نتيجه وجود انترناشونال تريتي. فالسؤال هان التريتي هذا اللي احنا بنتكلم عنها المعاهده زيها زي اي معاهدات بتبرم على الصعيد الدولي، زي المعاهده اللي بتبرم بين دوله الف وباء مثلا، يعني من حيث ابرامها، من حيث القيمه القانونيه الها، من حيث طريقه الانضمام للمعاهده، ام انه the international treaty which establishes the international organization, it differs from the other treaties in the international field. Well, actually, this is our question for today. This is the second main question. So the first main question is that how do international organizations emerge? They emerge through an international treaty, and this is according to the definition we have given you before. The second question is how how does the treaty which establishes the international organization differ from the other treaties, or is the treaty constituting the organization similar to the other treaties? Well, the actually is no. The answer is no. This treaty has characteristics that other international law treaties do not have or do not enjoy. So what are the characteristics that the international treaty which constitutes the international organization enjoys, however the other treaties do not enjoy? Well, the first character is that the method of admission replaces the method of accession. المعاهدة بشكل عام غير المعاهدات اللي بتنشئ منظمات دولية، طريقة انك تصير عضو او طرف في هذه المعاهدة هو طريقة ايه؟ طريقة الاكسيشن، الانضمام. يعني اليوم there is a treaty concluded between the states A, B, C, D, and F. Okay. Now I, as a state G, would like to be part of this treaty. Then all I have to do is to make the accession. أعمل انضمام لهذه المعاهدة. By this accession, I am a party to this treaty. However, if there is a treaty which establishes a universal, for example, universal organization, international organization, and I would like to be part of this organization, now the accession is not sufficient to be part of this treaty, simply because it's not a normal treaty. It is a treaty which establishes organization. So my accession to this treaty is not sufficient to be part of it. However, the admission process, it replaces this accession. ايش يعني الادميشن؟ اسلوب القبول. يعني كأني بقول الجمله كلها الخاصيه على بعضها، انه اسلوب القبول يحل مكان اسلوب الانضمام. القبول يعني انه انا بدي اقدم طلب انضمام للتريتي and the committee، اللجنه القائمه على هذه المعاهده اللي اصبحت بموجبها في معاهده في منظمه دوليه، هي اللي بتقرر whether to accept my accession request or not to accept it or to reject it يعني. And this depends on the fact that the state that wants to be part of this treaty, it meets or it doesn't meet the requirements according to this treaty. لأنه التريتي ممكن تقول إنه الدول التي ترغب في الانضمام إلى المعاهدة أن تنضم، لكن انضمامها مش كافي عشان تصير طرف، لازم تحقق معايير معينة. على سبيل المثال United Nations Charter بتقول إنه للدول أن تكون الحق في أن تكون عضوة في الأمم المتحدة، شرط أن تكون دولة محبة للسلام وكذا وكذا، ولازم يكون قد صدر قرار بالموافقة عليها من بأغلبية أصوات كذا وكذا وكذا. Then these are requirements. If they are fulfilled, then the accession in this case is admissed, and the state will be part or party to the United Nations. However, if the state doesn't fulfill or meet one of these requirements, then in this case, the accession request will be rejected. So this is why we can say that the method of the admission is important in the United Nations or any other organization treaty or treaty which establishes any kind of international organizations. So the method of admission replaces the method of the accession. So this accession applies to the other treaties. However, when we talk about the treaties which establishes international organizations, there will be a method, the method of the admission. We will illustrate this, inshallah, in more details. Number two, the supremacy of the treaty that constituting the organization. Now, this supremacy, what does it mean? We will discuss it later. What I need you to know now is that the treaty which establishes the international organization has the supremacy over any other treaties made by the state parties to the treaty establishes the organization, or even the internal system. We will discuss it in more details, inshallah. The third one is that the unity of the organization treaty provisions. وحدة الأحكام التي تتكون منها المعاهدة اللي بتنشئ منظمة دولية. الوحدة معناتها مبدئيا إنه no reservations are allowed. No reservations are allowed. And this means that the provisions are unified or united simply because the state which wants to be party to the international organization has to accept the treaty as it is. I mean, to accept all the provisions of the treaty simply because they are considered unified legal provisions. You have to accept them without any objection. It means no reservations, as we studied in the Public International Law Part 1. Okay? So the first one, which we mentioned here, the method of admission replaces the method of accession. Admission replaces accession. What do we mean by this? Well, actually, according to the jurist Rosini, the international treaty which establishes an international organization is a closed treaty. يعني بقول لي ببساطة أن المعاهدة اللي بتنشئ لمنظمة دولية هي عبارة عن معاهدة مغلقة. So the problems raises not in case of state's accession to the treaty. يعني المشاكل اللي احنا بنتعرض لها بالنسبة للدول اللي بدها تنضم للمعاهدة اللي بتنشئ منظمة دولية ما بتنشأش من لحظة الانضمام، ما فيش عندي مشكلة بالانضمام. But in case of the decision of the organization whether to accept this state or reject the states. Okay? إذا مشكلة اللي بتنشأ عندي مش مسألة انضمام الدول، المشكلة بتثور لما بيصير في قرار من المنظمة إنه أقبل هذه الدولة ولا ما أقبلهاش بناء على الشروط اللي بتكون الدولة هل حققتها أم لم تحققها. إذن نرجع هان لنفس الكلام، بقول لي إنه thus treaty may include conditions to accept the state within its scope. In this meaning, the jurist Boet says that admission is not automatic consequence of the statehood. Yani, if you are a state and you want to be a member state in an international organization and existed in an international organization, being a state doesn't mean or doesn't mean that you are capable to be part in this organization. There is conditions. That's why Boet said, but it is conditional of the fulfillment of the conditions of the Article 4 of the Charter. And he talks here about the United Nations. He said that any state cannot be a member state in the United Nations unless the state fulfills the requirements or the conditions mentioned in Article 4 of the United Nations. To be a state, to be peaceful state, wants to fulfill peace, and there must be a resolution made by the United Nations General Assembly. There must be a resolution or a recommendation made by United Nations Security Council. These are conditions actually. If these conditions are met, then the state can be accepted within the United Nations. This means to accede the international organization is not sufficient. You have to accede, and after this accession request will be verified by the United Nations Committee. The United Nations Committee, if it finds that the state which acceded the United Nations fulfills the requirements, then it is decision will be like positive, accepting the state which wants to be part of the United Nations. The second character, we say that the supremacy of the International Organization Treaty. This characteristic raises 2 points. احنا حكينا قبل هيك انه المنظمة يوجد لها حسب التعريف نظام داخلي اللي هو الانترنال ليجل سيستم، وانا بفترض فيكم انتم عارفين انه انا هذا جزء من التعريف، يعني انتم حافظين المكونات تبعت التعريف. فجزء من مكونات one of the components of the definition is that the organization has its internal legal system. So it has a statute, internal statute. And it is different from the treaty establishing the international organization. النظام الداخلي اللي بتكلم عنه غير عن المعاهدة اللي أنشأت الأمم المتحدة. يعني النظام الداخلي للأمم المتحدة بيختلف عن المعاهدة اللي أنشأت الأمم المتحدة اللي هي اليونايتد نيشن تشارتر. فالسؤال اللي بيطرح الموضوع لما أنا بتكلم عن سمو المعاهدة المنشئة للمنظمة، على سبيل المثال سمو ميثاق الأمم المتحدة، على مين يسمو بالضبط؟ موضوع السمو بخليني أتساءل، هل يسمو هذا الميثاق على النظام الداخلي؟ هذا من ناحية. من ناحية ثانية، اليوم احنا عندنا في مجموعة من الدول داخل الأمم المتحدة أبرمت مجموعة معاهدات، وبنفس الوقت هي مصدقة على معاهدة الأمم المتحدة، ميثاق الأمم المتحدة. If there is contradiction, if the treaties, for example, provisions, I mean the other treaties rather than the international organization, if they violate the treaty which establishes the international organization, let's be back to our example. If there are states concluded a treaty, and this treaty which is concluded between them, it contradicts or violates their obligations under the United Nations Charter, which one of these treaties shall be given priority? The United Nations Charter or the other treaties made or concluded between the states or the member states? So these are two questions. Number one, the supremacy. It raises two questions or points. The relation between the organization treaty, for example, United Nations Charter, and the internal statute of the organization. Also, the relation between the organization treaty, or charter, and the other treaties that member states are parties to. Okay? So let we here discuss the two scenarios or the two questions or points. Number one, the organization, it has its establishing treaty and it has its internal statute. أنا عندي معاهدة الأمم المتحدة، ميثاق الأمم المتحدة، وعندي النظام الداخلي. لو أنا قلت لكم مين اللي يسمو على الآخر في حالة تضارب، طبيعي جدا إنه ميثاق الأمم المتحدة هو الذي يسمو. لماذا؟ نتيجة منطقية. أنا اليوم أنا كمعاهدة أمم متحدة عندما أوجدت الأمم المتحدة أعطيتها إمكانية أنه تعمل نظام داخلي. فهل يمكن وأنا الجهاز المنشئ المعاهدة المنشئة، هل يجوز للمعاهدة الجديدة هذه أو النظام الداخلي للمنظمة اللي أنا أنشأتها كمعاهدة معقول أنه تيجي تخالفني؟ لا يجوز. يعني الإستابليشنج أورجان، الجهاز المنشئ اللي هو معاهدة الأمم المتحدة، لا يمكن أن يخالفها شيء أنا أنشأته اللي هو النظام الداخلي. كيف ممكن نصورها بشكل أبسط؟ اليوم أنا عينت بهاء برهوم فور إكزامبل، قلت له أنت يا بهاء بدك تكون سكرتير لأعمالي، وأنت مفوض أنك تعمل أشياء وفق الرؤية تبعتي. هلا بينفع يجي بهاء اللي أنا معينه أصلا وأنا جايبه يروح أعمال تتعارض مع سياستي أنا؟ لا يستطيع ببساطة، لأنه أنا صاحب السمو عليه، لأنه أنا اللي جبته. فكيف أنا يروح يحط أحكام بتخالف الأحكام أو السياسة العامة إلي؟ عشان هيك بنقول sure regarding the first matter the organization treaty is higher than the internal statute of the organization. This is logical because the established organ اللي هي الانترنال يعني legal system it mustn't violate the establishing organ. The establishing organ هنا مين قصده فيها؟ United Nations Charter كمثال. يعني أنا بتكلم بعموم، بس قاعد بضرب المثال أكثر على ميثاق الأمم المتحدة باعتباره الأشهر. Now the other case regarding the relation between the international organization treaty and the other treaties that the member states are parties to. Which one of them shall apply? Well, actually, this depends on the provisions of the organization treaty itself. So we have to look inside the United Nations Charter, what it reads or stipulates. Examples. Here, you may find that the treaty, it stipulates explicitly that its statute, I mean the treaty, establishing treaty, it has priority over the other treaties made and concluded between the member states. يعني كنا نقول إنه ممكن يكون المعاهدة اللي أنشأت المنظمة صريحة وقاطعة الدلالة بأنه هي تكون لها الأولوية على أي معاهدات يبرمها الدول الأعضاء. بمعنى إذا تعارضت التزامات الدول الأعضاء بموجب معاهدات أبرموها هم بينهم مع التزاماتهم بموجب ميثاق المنظمة، فإن ميثاق المنظمة هو الذي يسمو. مين اللي حكى هذا؟ ممكن يكون تم النص صراحة عليه في الميثاق اللي أنشأ المنظمة. يعني بيكون النص very crucial حاسم. So it may that it includes very crucial provision like Article 20 of the League of Nations and Article 103 of the United Nations. يعني في عصبة الأمم المادة 20 كانت بتقول إنه أي التزامات في عصبة الأمم تتعارض مع التزامات الدول الأطراف بموجب معاهدات ثانية، التزاماتهم بموجب العصبة أهم منها ويجب هي التي تنفذ. نفس الشيء في المادة 103 من ميثاق الأمم المتحدة. أحيانا الجماعة it also may include a semi-crucial provision. أحيانا بيكون في نص يعني بيعطي الأولوية للميثاق المنشئ للمنظمة على أي معاهدات تبرمها دول الأعضاء، بس بتكونش النصوص واضحة كتير أو خلينا نقول صريحة وقاطعة الدلالة، لكن يفهم منها إنه الأولوية تعطى لميثاق المنظمة. Like what? Like Article 234, Paragraph 1 and 2 of the Rome Statute, which established the European market. اتفاقية السوق الأوروبية، احنا بنسميها اتفاقية روما، بس مختلفة عن روما ستاتيوت تبع المحكمة الجنائية الدولية. برضو اسمها روما Treaty. It is regarding the European market. Let me give you examples here. I told you that Article 20, it was very crucial, and Article 103. So I will give you the examples here. I will make you read the text with me. Then after that, I will give you the Article 234, paragraph 1 and 2. Well, actually, Article 20 says the member states of the League severally agree that this covenant is accepted as abrogating, يعني هو بيلغي all the obligations or understandings inter se which are inconsistent with the terms thereof. Okay, this is enough. It is clear here that the United Nations obligations are obligating or abolishing or even abrogating all the obligations or the understanding inter se, I mean between the states, which are inconsistent with the terms thereof. Thereof means within the United Nations Charter. 103 United Nations Charter says, in the event of a conflict between the obligations of the members of the United Nations under this present charter and their obligations under any other international treaty or agreement, their obligation under the present charter shall prevail. So it is explicit here, according to Article 103, that any violation from the treaties to the United Nations Charter, the United Nations Charter shall be given priority and it shall prevail in this case. So the Article 20 and Article 103 are explicit and they are very crucial regarding the supremacy of the United Nations Charter. Now the third example and the last one is Article 234 says the rights and obligations regarding from convention concluded prior to the entry into force of this treaty between one or more member states, on the one hand, on one or more third countries, on the other hand, shall not be affected by the provisions of this treaty. Insofar as such conventions are not compatible with this treaty, now focus here with the black line, says the member state or states concerned shall take all appropriate steps to eliminate any incompatibility found to exist. يعني هو بيقول لي انه بالنسبه للمعاهدات اللي ابرمتها الدول الاطراف في معاهده السوق الاوروبيه، المعاهده اللي انشات منظمه السوق الاوروبيه، يعني اي معاهدات كانت ابرمتها من قبل وكانت هذه المعاهدات ليست منسجمة وأحكام معاهدة السوق الأوروبية اللي صارت الدول هذه الأطراف طرف فيها، فإنه يجب على الدول الأطراف أن يعني تأخذ بكل الوسائل الملائمة عشان تقوم بإزالة كل ما يتعارض مع معاهدة السوق الأوروبية. يمكن يعني بقول لك إنه أنت بدك تنضم لي بس في عندك التزامات تتعارض مع التزاماتي هنا في المؤسسة، فباجي بقول لك والله بكل يعني مثلا خلينا نقول أنا جامعة وبدي أوظف واحد بيشتغل في الحكومة، فبيجي عندي ممكن يكون النظام تبع الجامعة واضح وصريح إنه لا يجوز الجمع بين وظيفتك في الجامعة ووظيفة أخرى، بفهم إنه النص صريح بإنه يحظر على الشخص اللي يتوظف عندي يكون موظف في دائرة أخرى، فبكون عمليا النص الموجود عندي زي الارتيكل 103 and article 20. However, it may that the statute in the university says إنه أنت you are not allowed to work in the university, or if you want to work in the university, you have to take all the appropriate steps to eliminate any incompatibility with this statute or the university statute. يعني كنا بقول لك أنت روح ضبط أمورك وبعدين ترجع لي. شو مقصود بضبط أمورك؟ إنه روح قدم استقالتك من العمل الآخر وتعال عندي. فالعبارة هي مش صريحة كتير، لكن يفهم منها إنه المقصود إنه السمو بيكون يعطى من المعاهدة اللي بتنشئ المنظمة الدولية على حساب أي معاهدات أخرى بتكون الدول يعني أطرافا فيها. آخر شيء بدنا نتكلم عنه هو سؤال مهم هنا، واللي بيقول what if the treaty doesn't include any provision relating this supremacy. بدي يفترض لي إنه ماذا لو كان عندي معاهدة، والمعاهدة هذه تضاربت أحكامها اللي هي بتنشئ منظمة دولية مع المعاهدات اللي أبرمتها دول الأطراف، معاهدات أخرى. فرجعنا للستاتيوت المؤسس للمنظمة، ما لقيناش أي نص بيحكي عن إنه يكون لهذه المعاهدة السمو على أي معاهدات أخرى. فالسؤال، ما العمل في هذه الحالة؟ Well, logically, the International Organization Treaty, it must be given priority simply because it represents the public interest of the member states. However, the treaties which are concluded between the states or the member states individually, they represent a private interest, and the public interest must be taken into consideration over any private interest. يمكن بقول لي إنه المعاهدة بتنشئ منظمة بتهتم بالصالح العام، في حين المعاهدات اللي بتبرمها الدول بين بعض البعض بشكل منفصل تهتم بالصالح الخاص لهم، ودائما يجب أن نغلب المصلحة العامة على المصلحة الخاصة. لذلك يرى الكثير من فقهاء القانون الدولي أن ال International Organization Treaty shall be given priority whether there is a text which gives the international treaty which establishes the international organization the supremacy, or there is no treaty which grants the organization treaty the supremacy. So the supremacy must be given in all times to the treaty which establishes the international organization, and it mustn't be granted to the other treaties concluded between the parties or the state parties in this international organization. The last point to end this discussion, it is the unity of the international organization. This means that the state which wants to join the international organization shall not accept the treaty of that organization as it is wholly. So it shall accept, not shall not, sorry. Shall accept the treaty as it is. I told you before at the beginning of this lecture that the treaty which establishes the international organization must be accepted by the state as it is. So it must accept all the provisions of the treaty. This means that the objections are not allowed to make. I mean the reservations, تحفظات. However, what if a state wants to join a treaty of organization but wants to make sub-objections? يعني الأصل العام اللي بتفهموه إنه المعاهدة اللي بتنشئ منظمة دولية الأصل فيها إنه لا يجوز إبداء التحفظات صراحة هيك على النصوص الواردة فيها. يعني بدك تقبل الميثاق اللي بينشئ معاهدة بشكل واضح وصريح كلها. بعطيكم مثال الآن، يعني مثلا ال ICC the Rome Statute، لو أنتم فتحتوا article 124 I think 124 you will find the article 124 says that no reservations are allowed to made by the member states. ممنوع تعمل أي تحفظات على هذا الستاتيوت. يعني يمكن بقول لك حابب تقبل المعاهدة اللي أنشأت المحكمة الدولية الجنائية بتقبلها زي ما هي، ممنوع تعمل تحفظات. بدك تعمل تحفظات ممنوع تنضم للمعاهدة، خلص واضح وصريح. لكن سؤال، في منظمات أخرى ممكن ما يكونش في نص تكلم عن موضوع تحفظات. فالسؤال what if the state wants to join the international treaty however it wants to make reservations or objections on the treaty? Well, some say that it depends on the organization treaty position whether it permits or prevents. However, Vienna Convention on the Law of Treaty puts the rule in Article 220, paragraph 3. It is actually insufficient provision, and the Article 20, paragraph 4, it leads to illogical results, and we will actually illustrate these points, but not now. I will leave them for a new lecture, inshallah, in the coming days, simply because these points are debatable. So I don't have actually sufficient time in order to illustrate them in more details. So I will leave them, inshallah, to the coming lecture. Dear students, to this end, I think I reached the end of this lecture. I will inshallah give you the rest of the last point in the coming lecture. Thank you very much. Wish you all the best and goodbye. Well, I forgot to tell you something. Um, Next week you will have a quiz of 15 marks. So I need you to recap, to revise the lectures number 4, 5, and 6 till the categories, till the end of the lecture, which entail the categories of the international organizations. Uh, Thank you.